The state prosecutors have officially asked the Supreme Court of Illinois to step into the Quadajah Johnson case and reverse the appellate court's ruling that would have allowed Quadajah Johnson to be released before trial. The document is filed, the higher court has received it, and the people want to know what's really going on with this case. When people do the most, I do the analysis. Let's go. Today we have a major update in the Quadajah Johnson case because the prosecution filed a petition for leave to appeal known as the PLA, which means they are asking the Illinois Supreme Court to review the appellate court's decision to decide whether the lower court, the appeals court that is, misapplied the Pretrial Fairness Act. Right now, the appellate ruling that favored Quadajah Johnson's release is still on pause because the state previously obtained a stay. But here's a very critical part to pay attention to. This filing is about much more than Quadajah Johnson. The state is essentially arguing that the appellate court's ruling could impact detention hearings all across the state of Illinois under the Pretrial Fairness Act. After reading the state's filing, I can honestly say that this case has now entered a completely different level legally. So let's talk about what prosecutors are arguing. Why this case could realistically attract the Illinois Supreme Court's attention and what all of this could mean moving forward.
Enough is enough. This has to end. Now we have a dead police officer, Bartholomew, and another one clinging to life. How many more examples do we have to give? And I can give you dozens more. We don't have time, but I could, of terrible judgment by judges in this county.
Behind bars where he belonged. We have to change the law.
The Illinois Network for Pretrial Justice defended the Safety Act, saying no pretrial system can prevent every tragedy, but the right tools are in place, saying in a statement, quote, "What is clear from publicly available information is that there was absolutely nothing in the law that prohibited the detention of Alfonso Talley while he was awaiting trial. Any statement to the contrary is manifestly false."
The prosecutors are arguing that the appellate court made two major mistakes. First, they say that the appellate court wrongly treated the shooting like it was simply a personal dispute between two women. And second, they say that the appellate court improperly raised the state's burden when it comes to self-defense claims during detention hearings. Now, let's discuss both of those because this is where things get very important. The appellate majority basically looked at this case and said, this conflict grew out of a personal relationship situation involving the same man and children mothered by two different women. So they viewed it as more isolated and less indicative of an ongoing danger to the community. But prosecutors are strongly pushing back on that logic. The state is saying, hold on now, just because violence happens between people who know each other personally, that doesn't suddenly erase public safety concerns. Come on. And prosecutors repeatedly bring up the circumstances of this shooting. It happened in broad daylight on a school day. It happened on a public street. It happened near an elementary school, and the defendant shot more than once, even after a debilitating leg shot. And eyewitnesses at the scene are saying the victim was unarmed. The state argues that those facts alone can support detention. And honestly, this is where the legal battle starts becoming bigger than this one case. Because the prosecutors are basically warning, if courts start treating personal dispute killings as automatically less dangerous, that could dramatically narrow detention standards under the Safety Act. And y'all, the state is leaning heavily on Justice Mitchell's dissent. Justice Raymond Mitchell of the Illinois Appellate Court strongly disagreed with the appellate majority decision and eventually said this. Look here, arguments, emotional conflicts, jealousy, all that relationship drama, those are everyday human situations. And if someone responds to this kind of conflict with deadly force one time, the courts just can't assume that there is no future danger. How many times does a person have to respond this way before they are considered dangerous? That dissent is now becoming one of the central foundations of the state Supreme Court's argument. Now let's get into why that may actually become the biggest issue legally. Self-defense. The state says the appellate court essentially treated Quadajah Johnson's possible self-defense claim like prosecutors had to fully disprove it before detention could even happen. And prosecutors are saying this. That's not how detention hearings are supposed to work. Remember, y'all, this ain't even trial yet. At this stage, the state only has to meet the clear and convincing evidence standard. That's not the same thing as proving guilt beyond a reasonable doubt. And prosecutors are warning that if this appellate ruling is allowed to stand, then future defendants may be able to avoid detention altogether simply by presenting a possible self-defense theory very early on in their case. The state said that would basically turn detention hearings into mini criminal trials before the actual trial even happens. Now let's talk about something very, very important. A lot of people don't realize how difficult it actually is to get the Illinois Supreme Court just to hear a case. The Supreme Court does not accept appeals automatically just because someone disagrees with a ruling. Most petitions actually get denied. This high court is usually looking for cases that involve major legal questions, conflicting interpretations of the law, statewide importance, or issues that need clarification for lower courts moving forward. And honestly, this Quadajah Johnson case has several of those elements. First, this case directly involves interpretation of the Illinois Pretrial Fairness Act, one of the most controversial and heavily debated legal reforms in Illinois right now. Second, there's now a sharp disagreement between the appellate judges themselves. You had a 2-to-1 split decision with a very forceful dissent from Justice Raymond Mitchell. That matters a lot. Please don't think that it doesn't. Third, the state is arguing that the ruling could affect detention hearings statewide, especially in cases involving self-defense claims, personal disputes, and violent offenses involving firearms. And last but not least, this case raises broader questions that the Illinois Supreme Court may want to clarify sooner rather than later, because lower courts across the state of Illinois are still figuring out how to consistently apply the Safety Act. So while nothing is guaranteed, let's just be real about that, this is absolutely the kind of case that has the ingredients for a Supreme Court review. I'd be surprised if the defense doesn't take an opportunity to respond to this move with a motion of their own. But the Illinois Supreme Court first has to decide whether it even wants to take the case. In the case of a petition for leave to appeal, or PLA, the court takes roughly 3 to 4 months to decide whether it'll even hear your case after all petition documents have been filed. If they deny review, then the appellate court's ruling remains intact, meaning Quadajah Johnson would move forward toward pretrial release with conditions. But, if the Supreme Court accepts the case, this could become one of the most important Illinois detention cases we've seen under the Pretrial Fairness Act so far. But we have to be patient, because it could realistically take 6 to 12 months for the Illinois Supreme Court to issue a final decision, because the court could end up clarifying what counts as dangerousness, how self-defense should be evaluated at detention hearings, and how much evidence prosecutors actually need to keep someone detained before the case reaches trial. And don't forget, the stay is still in place right now. So Quadajah Johnson remains detained while the Supreme Court decides whether or not to even intervene. This case is no longer just about the appellate ruling. It's becoming a statewide legal debate about public safety, self-defense, detention standards, and the future interpretation of the Safety Act in Illinois, which includes the Pretrial Fairness Act. And depending on what happens next, this case could end up shaping detention hearings across the state of Illinois for many years to come. If you enjoyed this video, please give it a thumbs up and share it with someone who can use this message. Subscribe to the channel if you haven't already done so, and leave a comment down below letting me know your thoughts. Do you think the Illinois Supreme Court should take this case? Or do you agree with the appellate court's decision to release Quadajah Johnson pending trial? Meet me in the comments. We can continue the conversation there.